Afternoon, Alex.
Good afternoon, Marco. How are you doing?
Yeah, very well up here in Costa Blanca. And yourself down in Marbella?
Yeah, all good down here on the Costa del Sol.
Sun's shining as usual.
The sun is shining, yes.
Yeah, it's been beautiful actually, hasn't it, for January?
Yeah.
Okay, so this is a live session with Alex Radford from Legal Services in Spain. As you can see, legalservicesinspain.com, and underneath that banner, we've got many other headings, which are your main line of services. Today, we're going to concentrate on inheritance, which is inheritingyourSpanishAssets.com. You can see behind me in purple there a nice bright logo. But you can reach inheritingSpanishAssets.com either through Legal Services in Spain. It's all the same business, isn't it, Alex?
Yeah.
Just an introduction then, Alex, from you.
Yeah, so my name is Alex Radford. I'm an English solicitor and Spanish lawyer. I've lived in Spain now for nearly 30 years, and we act for British clients buying, selling, inheriting property in Spain, and also doing business in Spain. And today we are talking about estate planning. It's part one of our series, Here Today, Gone Tomorrow. Yeah.
So really, the thing is, for me, people like me that don't really have a clue about this, Alex, this succession of interviews, which is quite in depth, so it needs to be done in parts. But really, the start of this is for anybody that is either already in Spain or is looking at buying a property in Spain or having any assets in Spain. Whether it be a holiday home or whether it be a permanent place of residence. And it's the protection part that you're going to explain why people should start to think about this, because it's a foreign country. They probably don't have a clue. So where does your advice start from?
So you make a good point there, Marco. So in effect, when someone decides to move to Spain to buy a property in Spain, that's the ideal opportunity to have a conversation about who to buy the assets in the name of, who pays for them, who's in whose name they'll be registered, and then to put in place things like Spanish wills, etc. Because that upfront conversation can save quite a lot of money further down the line when it comes to inheritance tax. So recently I acted for clients, and they said they were buying a second property in Spain, and the client said to me, "Look, I'm going to buy it in my name." I said, "Is there a particular reason why you're buying it in your name?" And he said, "Yeah, because I bought the other one in my name." So I said, "Well, how much was the other one?" He told me how much the other property he purchased was, and he said, "Look," and I said to him, "Look, if you buy this one, when you pass on, who would you leave those assets to?" And he said, "I leave them to my wife." So I said, "Well, at the moment, your wife would probably end up paying about 60,000 euros in inheritance tax in Spain alone, just for inheriting an asset, which you can put in joint names now." So that conversation saved them 60,000 euros. So before someone buys a property, I think it's worth considering ownership options. Are you going to move to Spain? In which case, I'd certainly recommend buying a property in your own names. If you are going to buy a holiday home and you've got children over the age of 18, then it might be an opportunity to discuss potentially putting the property, adding them as legal owners of the property, along with the adults as well. So just, when I say adults, I mean mum and dad. So mum and dad and the parents have the property. So we've done that for mainly for people who are buying holiday homes. Have a think about maybe owning it with children and parents together.
So really, you're advising joint ownership is a much better plan going forward than just having a single ownership or a husband and wife.
Absolutely. So, I mean, this only really works, Mark. Each person's circumstances are different. So if you said to me, I've got young children. If I died, I'd want everything to go to my wife because my children can't manage my affairs. You're absolutely correct. You then have a Spanish will and you leave everything to your wife. But up front, certainly aim to buy the property in joint names, because in Spain, whoever inherits the property pays the tax. So the more they inherit, the more tax they pay. And because we've got 17 different autonomous regions, we've got different inheritance tax tables in each region. The most important ones we've put on our website, the inheritingSpanishAssets.com, so people can look at the tables on there, and they can more or less calculate or have a rough idea of the allowances they'd have If they wanted us to calculate the inheritance tax for them, we can of course do that for them.
Okay, so that's the first point. People that are looking and if at buying a property, but if they've already lived in Spain, they're living here, such as myself, and they haven't got a Spanish will and they haven't protected anything looking further down the line, where's the point? What do they do now? What can you offer them to sort this out?
So essentially, anyone who's got an asset in Spain should have, in my opinion, a Spanish will. A Spanish will is not compulsory, but it's strongly advisable. A Spanish will can help you mitigate inheritance tax. It can ensure that the assets in Spain go to the people that you want them to go to. And upon death, Marco, it will make life much easier for the heirs to come along, use a Spanish will to accept the inheritance in Spain of those Spanish assets. And if someone's got assets in other countries, then we would recommend that you have a will in that country. So if you've got assets in the UK or Sweden or Norway or America, have a will in each of those jurisdictions, and then have a Spanish will for your Spanish assets. Yeah. And they work together. It's very important that they work together, because the first clause of many international wills is, I revoke all former wills. And if you'd signed a perfectly valid Spanish will in front of a notary here in Spain or in your home country, and then you asked your lawyer in your home country to update your will, and they put in that clause, I revoke all former wills, that would revoke the Spanish will. So then you might have, and I've come across this, I've seen international wills that say, I revoke all former wills, and then they only have this international will referring to the assets outside of Spain. So they think that because they've got a will in their home country, they haven't revoked the Spanish will, but in fact they have. So very important.
How do you stop that happening?
Well, how to stop that happening? Make sure that when you sign a new will, that your lawyer is aware that you've got a will, and they have to work together. So you refer to the will. So you could say, I revoke all of my former wills except my Spanish will dated X.
Right. So that's a clause that everyone should be aware of when making a will, that it doesn't exclude or revoke their other wills, and they can include their other wills without that happening.
Absolutely. That's really, really important.
Yeah.
So, we talked about the ownership options. Ownership options, when you're buying a property, that can reduce inheritance tax as well, because again, in Spain, there's no free transfer of assets between spouses. So in other countries, you've got different titles, different forms of ownership of property. For example, in the UK, you've got joint tenancy. So a husband and wife can own a property, and when one of them dies, the other one inherits it automatically. And you just send a form off to the land registry, and you can transfer the ownership. That doesn't happen in Spain. Right. And assets don't transfer automatically. So in effect, spouses who own property together and they've left assets to each other, they have to come forward and accept that inheritance. And depending on the value and where the property is located in Spain, the region and the tax tables that apply, they may or not pay inheritance tax. So again, right up front, Marco, it's good to talk about, okay, I'm owning the property now, I'm here today, or I'm just about to buy the property. How can I mitigate inheritance tax going forward?
Yeah. And let's just pause there for a moment. In regards to Spanish people that obviously know all the rules, they've lived, they've been born in Spain, the families give them advice. Is it correct in saying that in most Spanish cases, the properties are owned by the rest of the family, as in the daughters, sons? So they don't keep it in their name.
What happens when in Spain, the inheritance tax laws in Spain for Spaniards are different to those of other European countries. So each European country has different rules and laws. So in Spain, 2/3 of the assets upon death have to go to the children. So if you've got a married couple and they own two properties and they own them in equal shares, 50-50, when one of those dies, 50% of that property would go, so 2/3 of that would go down to the children. But that's only to Spaniards here. So what you do find out with Spaniards is that I've acted for clients buying property from Spanish heirs and beneficiaries, and I can remember a time where we acted for clients and they purchased a property from 13 heirs. So because they had there's lots of brothers and sisters, and the family had kept on. The family, various people had died, and they hadn't dealt with the inheritance. So we had 13 heirs. 13 people came along to the notary to accept the inheritance. Thankfully, that doesn't happen, for example, with English law as much, because people come forward, they accept the inheritance, and under English law, we have free disposition of assets. So people in England, in the United Kingdom, have free disposition of assets. They can leave their assets to whoever they want.
Yeah.
Right? Spain can't. They've got forced heirship rules. 2/3 of their assets have to go to the children.
So how does that affect then British people living in Spain?
But British people living in Spain can leave their assets to whoever they want.
Right. Okay. So that's fair enough. Okay.
But they've got to put a will in place to reflect those requirements. So if they didn't put a will in place, they didn't have a Spanish will, and they moved to Spain and lived for numerous years, then they could be treated as a Spanish national upon death without a will, which means that Spanish inheritance tax laws could apply, which means that their assets could go 2/3 to the children instead of, say, to a spouse. So that's another reason for having a Spanish will. So you make it absolutely clear who you're leaving your assets to, and in that Spanish will, you can choose the law. So you can say, right, I was born in the UK, I want the laws of England and Wales to apply, and that means I can leave it to whoever I want. And under Regulation 650, I can state English law to apply. Right. And I've chosen the law, and I've chosen my beneficiaries, and upon death, my wishes will kind of be will be adhered to. If I didn't have a Spanish will, then in effect, the more time you spend here, Spanish inheritance laws start to apply.
And what does it make a difference if a British person was a resident in Spain with their TIE residencia, or whether they're just under the 90-day rule?
Yeah, absolutely. So if you're coming to visit your holiday home and you're not a resident in Spain, and you pass away and you haven't got a Spanish will, then your English will would apply if it refers to Spanish assets. If it didn't refer to Spanish assets, then your heirs and beneficiaries would have to apply to the UK for what's known as letters of administration, and that can take 4, 5, 6 months to get through. So one of the advantages I mentioned earlier about having a Spanish will is that upon death, the heirs can come forward and deal with the estate really quite quickly. Right. And there's no hold-ups because there's a Spanish will in place, and you can move quite quickly to inherit the assets. And lots of times that is necessary, especially if you've got mortgages in place, if you've got children, school fees, you need access to money, etc. So all of those reasons, for the sake of a cost of Spanish will, we'd strongly recommend having a Spanish will, and that can mitigate significant amounts of inheritance tax.
And that obviously applies not just to the property, but because of bank accounts not being embargoed and frozen. I've heard of some real horror stories for people that have been left with literally no access to the money because the husband or the wife has passed, and because it's a joint account, it's frozen.
Well, what actually happens is the bank here in Spain, upon being notified of a death, they will freeze 50% of the bank account, but they will allow direct debits and expenses to continue to come out of the bank account. So basically, back to the here today, we've talked about the benefits of a Spanish will. For the sake of a few €100, we charge online. It's €212 for a Spanish will. You can sign that in Spain, or you can sign it in your home country. It's got to be signed before a notary. It's got to be stamped with the apostille of The Hague if you sign it outside of Spain. If you sign it in Spain, then you sign it in front of a notary here, and they'll let the civil registry know that you've signed it. The civil registry will keep a record that you've signed a will in front of that notary. So upon death, you go along to the civil registry, and they'll confirm where and when the deceased signed a Spanish will. So it's a great system. Mm-hmm. Moving on then, apart from a Spanish will, which we've talked about the benefits of, the other document that people can sign is a power of attorney. So while I'm still here, I'm mobile and I've got my mental capacity, but I'm worried that maybe further down the line I might start to suffer from a degenerative illness that could impair my mental capacity. Let me put a power of attorney in place. And a power of attorney I could sign that in favour of my wife or a trusted person. It has to be a trusted person. And basically, that power of attorney will allow them to govern my affairs. They can open bank accounts, they can close bank accounts, they can take money out of bank accounts, they can sell property, buy property, issue legal proceedings, a broad range of powers and faculties to carry out.
Right.
Now, when I die, that power of attorney dies with me, so it comes to an end. But until I die, that power of attorney continues to exist until I lose my mental capacity. And then when I lose my mental capacity, then you would go along, the person who has the power of attorney would basically have to apply to court and be appointed as a guardian so they could manage my affairs. And the fact that they've signed a power of attorney means that the court will look favourably on that applicant and probably 9 times out of 10 grant them the guardianship of that person, because that person has already indicated in a power of attorney that they want the applicant to court to look after their affairs.
Right. So really, with a power of attorney, you're recommending that to be the closest person to you, so the husband or wife, or a very close member of the family, and that power of attorney is just going to sit there until such time it's needed and protect that person for the future, just to make sure that they're covered in every angle, that that their affairs are going to be taken forward for them, looked after. And it's just something that should only really be taken up by somebody who thinks that they have an illness or a reason to do that.
Yeah, I mean, it's a good document to have. You never know what's around the corner. So I recommend powers of attorney to healthy people who have just purchased a property. Let's sign the Spanish will. Let's sign the power of attorney to each other. You could walk out the notary after the purchase of the property, you get knocked down. Okay. Or 20 years time, you start to suffer degenerative illness. That power of attorney is just it's another document that makes life easier for your family members to govern your affairs if you're unable to do so.
Yeah, and that's probably mainly because obviously foreign country rules are different, laws are different, and it just covers both parties. If it's a single person living on their own, then they would appoint the nearest closest person to them, a member of family. They don't have to live in they don't have to live in Spain to have this done.
No, they don't have to live in Spain. But what is very important, Marco, is that they do appoint someone who they trust. Mm-hmm. Without any reservations whatsoever. Of course. Because you're giving the crown jewels to that person. Yeah.
So very good advice. The Spanish will, the power of attorney, both at the same time. You can take on that task, and it's fairly simple, and it's quite reasonably that most people can afford to have this done. It's not an expensive job.
Exactly. So we would recommend that when someone buys a Spanish property, that they put in place the Spanish will and that power of attorney. The costs are set out on our website under our fees section. And another very useful document is a letter of wishes. So someone's moved to Spain, they live here, they might have a nice watch, might have some jewelry, ornaments in their house, a car, so special items, and they want those special items. Sometimes don't even have to a value; it's just a sentimental value, and they want those items to go to a certain person, a certain loved individual. So in those situations, we would recommend a letter of wishes, and that document is essentially a letter where you set out that you've got X amount of items and you want to leave them to X person. Right. And we would keep that letter with the power of attorney and the Spanish will.
And that letter is because those items aren't listed within the will. It's an attachment. It's an annex to the will that makes life easier just to cover each and every item that you want to grant to somebody else.
Yeah, not normally in Spain. You only really refer in the Spanish will. You only really refer to your big items, so a house, a car, bank account, shares, assets, bigger assets. If you rings, watches, items of sentimental value, we wouldn't normally include that in a Spanish will. And that's why we would recommend a letter of wishes to cover those circumstances.
Yeah, fair enough. Fair enough. In normal circumstances, that's the way you do it. So the package then is the letter of wishes, the power of attorney, and the Spanish will.
Yeah.
Remembering to make sure that the Spanish will is not claused out when a will abroad in another country is then updated, because that's a normal clause, to make sure that it doesn't delete the Spanish will.
Yeah.
And that then makes everyone a lot more comfortable living in a foreign environment and not being caught up with what complications can happen. And unfortunately, at the worst time, when people really don't need complications and extra stress, makes that perfectly easy to deal with all of their affairs. So that's recommended, and that makes that makes it easy then for us to talk next time about what else do you recommend.
Yeah, well, as well as that, so we're talking about the here today. So here today, you can put those Spanish will, power of attorney, the letter of wishes in place, but also you can do other things. So, for example, you've got to think about when you pass away, how is the person you're leaving the assets to going to manage your affairs? So you should, in effect, I'd say, start sharing information about your property, about your assets with the trusted people, or prepare a letter of instructions. So I'd say, collate all the information about your assets, where they're located, where they're registered. Share that information with your trusted family members, so that they're aware of what to do when the time comes. Lots of us may have too many bank accounts. Close some of those bank accounts down. Start just putting your affairs in order. So I'd certainly recommend people living in Spain collate a list of assets, collate a list of important docs. So they've got one folder in one place with the Spanish wills in there, the power of attorney, letter of wishes, and say the deeds of the property, details of the bank accounts, and those that folder is ready, perhaps with a letter saying, look, maybe call Alex legal services in Spain if you want, or call your other lawyer, call someone when the time comes, and they can talk you through the next steps. But in the meantime, here are the list of my assets. And that's really quite important, I'd say, Marco.
Yeah.
And then I mentioned earlier, whoever inherits the asset in Spain pays tax. Okay. So also there's a lot of people living in Spain and they're not married. And essentially, if they did get married, there are more allowances for spouses than non-spouses.
That used to be the case in the UK, didn't it, years ago?
Yes, yeah, absolutely. You had common law wife, and basically a common law wife for a husband. It doesn't exist, and now we've got civil partnership. But in Spain, we have got what's known as the pareja de hecho, and we've also got we've got kind of civil ceremonies, so people can get married. So if you are living in sin, so to speak, I'd certainly suggest that people look at those options, because, again, someone would pay significantly more inheritance tax if they were unmarried compared to if they were married. So
they really got to sort that out. Yeah.
So, I mean, it is amazing. We've spoken to clients who are moving to Spain, they're unmarried, prepared calculations for them on inheritance tax. And they go, wow. I said, look, if you get married or enter into a kind of form of civil partnership, then in effect that inheritance tax liability disappears. And lo and behold, they come to Spain, they've got a ring on their finger, they've got married. So
there's always a reason. There's always a reason. It's
the most unromantic reason, Marco, but it is a reason. Yeah?
Okay. Is there any advice there, Alex, on having assets registered? Are you allowed to have your Spanish assets sort of in the name of the UK company, or any way that people can protect their assets from being taxed in Spain?
Yeah, I mean, that comes back to the ownership options. So when someone's looking at buying a property, it's important to consider all ownership options, whether you buy it in the name of a limited company or you buy it in your own individual name. Generally speaking, unless it's multi-million euro villa, it's probably best to buy it in your own names, maybe along with the family members, to mitigate inheritance tax. But each person's circumstances are different, so we would look at those individually. And rule of thumb, I'd say, if you're moving to Spain, as opposed to having a holiday home, definitely buy the property in your own name. Because, for example, if it's your main residence, you've been a resident in Spain for more than 3 years, as a tax resident, so you declared tax in Spain on worldwide income and assets, and you're over the age of 65, there's no capital gains tax when you sell a property.
Right.
So if you bought a property and you put it in a limited company and you wanted to sell it, you pay capital gains tax. You pay corporation tax in Spain. Sorry. Whereas if you bought it in your own individual names and you over the age of 65, 3 years tax resident here, and it's your main residence, no capital gains tax at all. So that's why I think it's very important to discuss ownership options up front when considering a property purchase.
Great advice, Alex. And just to recap on this, obviously there's more to come in our next part, but people can get this advice from you personally. They can contact you directly either through the website, which obviously legalservicesinspain.com or inheritingSpanishAssets.com. There's a contact us form there. Your phone number's on there, I've noticed, and your mobile number as well. So there's a direct contact there, and you cover the whole of Spain.
Yes.
And that can be talking obviously directly to you, but then people can make an appointment with a local office and actually get to meet somebody.
Yes, that's right. Yeah.
And do their documents that we've referred to get held in a strong room here in Spain?
No, when you sign a Spanish will, the notary holds on to the original signed version, and gives you the first authorized copy. And so in effect, the notary holds on to the original, and you've got a copy. So there's no need to kind of store those documents. And deeds, when we act for clients in property purchases, we always return the deeds to them. So the client would hold the original deeds.
Okay. And the letter of wishes?
The letter of wishes. So if someone instructed us to prepare powers of attorney for them and wills and the letter of wishes, and they wanted us to hold on to them for when the time comes, then to then contact their heirs and beneficiaries, we'd happy to do so. To do that, yeah.
Okay, that's it for this session, isn't it, Alex? And we've got more to talk on the subject next time.
Look forward to it.
I believe. Yeah.
Look forward to it, Marco.